Mr. Pirolli, on page 3 of your direct testimony, if we can get that up, you say, I don't have a line number in my notes, but you say that the pipeline will benefit the environment by removing CO2 from the atmosphere. That's a line 10, it looks like. Isn't it true that the process does not remove CO2 from the atmosphere? It attempts to prevent CO2 from going into the atmosphere, correct?
That's not correct.
Why not?
Because it's not an avoidance project. It's a removal, because the CO2 is removed biogenically by the corn plants when they grow and through the photosynthesis process. Corn plants absorb CO2 from the atmosphere as they grow, put the carbon into the corn kernel. Some of that goes along to the ethanol plant. It's released during fermentation, and that's the CO2 that we're capturing and putting back down underground. And we look at those removals on a net basis, which is net of any additional emissions created through energy required in the process. So from that perspective, these are considered removals.
But there is such a thing as direct air capture. Are you aware of that?
Yes.
This is not direct air capture, correct?
No, it's not. Direct air capture generally refers to a mechanical process using fans and filters. This uses plants instead of the fans and filters, so we call it Mother Nature's direct air capture.
But you're not taking the CO2 out of the atmosphere, are you? You're preventing it from going into the atmosphere from the ethanol plant, correct? That is the point that we are capturing the CO2, but it is removed in the first place on the farm by the corn plants. So direct air capture, Mr. Taylor, you can see it's a very short line from fans and filters remove the CO2. It's absorbed by some type of a filter material and chemical, and then there's a process by which that carbon is released from the filter material, and at that point it's captured and compressed, and something else is done with it. And instead of using fans and filters, we're using plants, we're using biology to do it. Now, isn't it true, as you say, that the corn in the field sequesters carbon dioxide?
Well, while plants grow, there is some benefit to the soil also. So when a corn plant absorbs, 14 or on an acre of corn, and this depends on the yield and number of plants, but roughly 14 tons per acre while the plants are growing, roughly half of that stays in the field with the corn plant, the stalk and the stems and the cob and the leaves. Some of that is reincorporated, and that carbon, those nutrients stay in the soil. A lot of it is released back via the carbon cycle. However, we're looking at roughly half of the carbon that stays with the corn kernel that goes to the ethanol plant. Some of that goes on with feed products. Some of it goes on with corn oil. A lot of it goes on with the alcohol. But a portion also is released when the yeast consume the sugar. So they consume sugar. Those are those short carbon chains. Half of that goes to alcohol. Half of it goes to CO2. That's what we're capturing there. So the corn plants absorb CO2 out of the air. We're reclaiming that, and we're putting that back down underground.
But let's look at the process here. The corn growing in the field,
sequesters carbon.
Yes.
Yes. The corn is then harvested, taken to the ethanol plant, instead of being used for feed or some other thing that would keep the carbon in the corn, and the ethanol plant creates more carbon that you have to capture in order to keep it from going into the atmosphere, correct?
Well, I think back up to what you were saying at first, when corn's harvested in Iowa, it's the combine shells the corn. So the only thing that leaves the field are the corn kernels. And whether that goes to an ethanol plant or it's fed to, hogs or chickens or transported somewhere else in the world to do something else, the same amount of crop residue stays in the field, whether the kernels go to an ethanol plant or to a hog farm.
But the carbon would stay in the kernels. It wouldn't be transformed into ethanol and producing carbon dioxide that you claim has to be captured, correct?
So the same amount of carbon stays in the field, right? And then the kernels go on and something else is done with them. And through the cycle, whether an animal consumes the corn, something happens on that chain, or we convert it to some of it to alcohol and some of it to feed products, which are ultimately fed. Either you capture CO2 off of fermentation and sequester it, or all of that carbon eventually is going to be released back into the atmosphere in some form.
Farther down on page 3 of your testimony, you say that the pipeline will make ethanol a net zero fuel. Have you done any calculations on what it would take to make ethanol a net zero fuel?
So yeah,
Have you done any calculations?
yes, and this says to reduce their carbon footprint by as much as 50%, which is the claim that's factual and has been backed up, extensively, putting them on a path towards net zero carbon. So this specifically, that if the CI score of the plant is 60, it's not going to reduce the carbon score by 60 points. It's going to reduce it by 30 or 35. So putting them on a path without doing this, it would be very difficult, if not impossible, to get ethanol to become net zero carbon. But this is a key fact in doing that. And there's other things that would need to happen, but this is the largest opportunity.
But you have not done any calculations.
We've done extensive calculations.
Who's we?
Summit and our environmental engineers, and I think a lot of it's available out there generally by the industry as well. It's a process, as I mentioned earlier, that every ethanol plant that I'm aware of that I've worked with extensively in our project and outside of that is very focused on their carbon strategy. And so CCS can have a benefit, process improvements can have benefits. There's significant work being done on the production of corn and feedstocks upstream. So there's a lot of things that would need to happen, and each of those has an impact on the carbon score, and those numbers have been calculated and are widely known.
But you haven't provided them with your testimony, correct? The calculations, I mean.
I thought some of those calculations were included either in testimony or in the responses and the questions. I know we went through those calculations that equate, how many tons of CO2 are produced along with one
1 gallon of ethanol. So I think that's all been provided.
On page 5 of your direct testimony, starting at line 5, you talk about the 12 ethanol plants and a variety of industrial facility owners in Iowa and surrounding states that you're offering Summit services to. And you include ethanol plants, nitrogen production, and other industrial sites. What other industrial sites or what other industrial facilities are you referencing there?
Other large industrial emitters of CO2, which could be cement plants, steel mills, power plants, those would incorporate the majority.
Have you been soliciting those kinds of customers?
Yes.
And I take it you had no takers at this point.
Well, we don't have any transportation agreements signed yet.
Would those other industries assign what you've called the transportation service agreements, or would they assign offtake agreements?
In general, they would sign a transportation services agreement.
Why that instead of an offtake agreement?
Just because of the economics and the nature of some of those facilities. The business model that we created for ethanol works very well for that industry for a number of reasons, whereas things like nitrogen fertilizer production, and I'm not an engineer and expert in that process, but it relates to the way CO2 is produced and sometimes reused in that process. It's pretty integral in the production of fertilizer, and so that capture equipment is also very incorporated within the process at the facility, and they would, those companies would generally are interested in making those investments and in building that infrastructure, and in that situation, they would claim the 45Q tax credit as the owner of the capture and compression facility, and they would pay us for transportation services.
So why haven't these other industries assigned agreements with Summit?
Well, as I said, we're close with several, but a lot of it came down to they were researching it when the 45Q tax credit was at $50 a ton, and we're getting the economics around there, and it was unclear whether or not it would be economically viable for them to do it at a $50 45Q. But once that was increased to $85 per ton and more clarity has been given around that, that has pushed some industries over the hump, I'd say, on making it an economically viable investment. But it's a significant project. I mean, tens of millions of dollars, very complex. The equipment and the technology exists, but they need to go through the process of engineering, design, and their own RFP process to line up, construction and equipment and get all of that to a point where they'd be able to look at that plus our transport agreement and say, okay, this is a holistic business model that's going to work, and then move forward. And those projects take a while to get developed. So as I said, we're close with some. There's been a redacted
transportation agreement that's under negotiation that's been provided that you guys have seen, and we're continuing to work forward on those.
And it's true, is it not, that with these other industries, unlike the fermentation process from ethanol plants, it's much more difficult and expensive and involved to create the carbon dioxide in a form pure enough to put on your pipeline, correct?
That's correct, Mr. Taylor. Generally, because the cost of the cost is affiliated with the purity of the CO2 gas that's being captured. So a process called steam methane reforming, which basically cracks natural gas and creates hydrogen and carbon dioxide, that produces roughly an 80% pure CO2 stream. So after ethanol, that's 97% pure CO2 coming off of fermentation. All we have to do is compress and dehydrate. Then you get a stream that's 80% pure. So there's more impurities that have to be removed from that stream. So that relates to the cost from to your point, all the way down to what's called post-combustion, or any time something is burned and you take the flue gas stream that could be 4 to 10% CO2, that then would be incrementally more expensive to remove the CO2 from that very low concentration stream. So it relates to the concentration.
And so even with the increased 45Q tax credit, with these other industries, it's still a sort of a tenuous economic proposition as to whether they want to go ahead and sequester the carbon and put it on your pipeline, correct?
I believe it's definitely moved the benchmark. There's some processes and facilities that are now believe that it's a viable process, and then there's some that are still unsure about it. And it's a large investment.
Mr. Jorde asked you about the open season that you claim Summit is going to have. As I understand, you don't know when that's going to be, correct?
Correct.
And do you recall your deposition being taken back on July 7th?
Yes.
And I asked you about the open season, and you said that your legal team and regulatory team said it's a requirement to do. So who requires it?
I guess it's more of an internal requirement that we're putting on ourselves to to conduct that process in a formal manner.
And didn't you also say in your deposition that as far as you were concerned, you were already conducting an open season with your solicitation of various industries?
Yeah, in a manner, I think that's true. That's why I come to work every day. That's what I was hired to do, is to bring more volume and more partners into the system. But at the same time, in my understanding, there's certain specific and more formal processes that go along with a formal open season that we're going to conduct at some point in the future.
I guess my question still is, who is requiring the open season? Is there some regulatory agency that you think is requiring that?
Not at this point, but we feel that it's a prudent process to go through.
And isn't it true that the reason that your legal and regulatory team said it's a requirement is so that you can present the facade that Summit Carbon Solutions is a common carrier?
Objection, Your Honor. Legal conclusion that invades attorney-client privilege. do you have a response, or do you just want to
Well-
reword or move on?
My response is that he said in his deposition that it's a requirement, and I'm trying to find out why he thinks it's a requirement.
I think that's asked and answered, but more importantly here, and maybe Wally can, Mr. Taylor can just rephrase the question, but the way it was asked, I understood to be asking about his conversations with his legal and regulatory attorneys, which would invade privilege.
Any
Well,
response?
he's the one that brought it up in his deposition about talking to the legal and regulatory team.
Okay. You may answer if you'd like. We need to move to the next question shortly after. And Mr. Taylor, you can move that microphone around anywhere you'd like to get comfortable. We got plenty of room. There you go.
Sorry, can you repeat the question you'd like me to answer?
Can the reporter read it back? I've forgotten exactly how I asked it.
So the answer overall to that is no. I don't believe that, whether or not we hold an open season is a determining factor on whether the pipeline is a common carrier or not, and certainly I don't think that there's anything in that that's a facade.
In your rebuttal testimony on page 6, starting at line 14, you say, moreover, we will be conducting what is known as an open season to solicit interested shippers, and that we will be reserving 10% of the pipeline capacity for walk-up shippers, those who are not shipping pursuant to a long-term commitment. Define more specifically what you mean by walk-up shippers.
I would consider a walk-up shipper or an uncommitted shipper. We hear some of those terms used interchangeably as a shipper that does not have a long-term commitment on the pipeline. So they haven't committed to consistently shipping, and we have not therefore reserved capacity for that shipper.
And you say that those would not be long-term contracts. What do you mean by long-term?
Well, some length of time that, is, we deem is reasonable to, to reserve capacity for that shipper. And it could be a range of different things, but as we discussed earlier, there's going to be, there could be different classes of shippers. Those could generally be related to the amount of volume and the type of commitment that they're willing to make. But the answer, Mr. Taylor, is years, not days or weeks or months.
Okay. So what shipper is going to spend millions of dollars for capture equipment, for a pipeline lateral up to their industrial facility, for a week or a month or even a year contract?
what, sorry, can I try and repeat that? What, you asked me what shipper is going to spend the money to make the investment to ship CO2 on our line?
To be a walk-up shipper like you've described it, it would be very short-term, no particular commitment on volume.
Well, I think, you know, there's trade-offs either way. So generally a committed shipper is, you know, is very interested in securing volume capacity on the pipeline so that they know that we've reserved that for them. And we also know that we're going to have that, or any pipeline would know that they're going to have consistent revenue coming in from that shipper, and there's requirements along with that. There could be, in the other case of an uncommitted shipper, it doesn't mean that you know, that it's not that they're not going to be shipping for months or years into the future. It just means that they have not made that commitment, and we have not reserved pipeline capacity for them. So as long as there is capacity on the pipeline that's not being used, and they wish to ship, they can do so. And there's uncommitted shipping arrangements that go on for years and years into the future perpetually. It just depends on whether or not you know, a shipper wishes to make, you know, that firm take or pay commitment. So there's trade-offs either way.
But my question was, why would a walk-up shipper, as you've described it, very short term, no commitment in volume, spend the millions of dollars it would take to buy the capture equipment, to build a lateral to their industrial facility?
Well, maybe they feel that in their analysis that they're comfortable with that whatever is the uncommitted capacity that's made available on the pipeline, whatever pipeline it is, natural gas or CO2 or anything else, that capacity is going to be there, and they don't wish to take the risk of a take or pay agreement, which means that if their facility is not operating, they still have to pay the committed fees. The commitments are bilateral. If they want the capacity on the pipeline, they have to pay whether they use it or not.
I have some further questions, but we'll wait till the confidential session regarding that. I'm not done yet, but I mean, just, sorry. I hate to get your hopes up. So, it's true, isn't it, that the Federal Regulatory Commission, the Federal Energy Regulatory Commission, or FERC, does not regulate CO2 pipelines?
That's correct. That's my understanding.
And so when you talked about a tariff rate, there is no agency that imposes or reviews a tariff for CO2 pipelines. Isn't that true?
That's true.
Okay. So why do you use the term tariff rate? There's no tariff.
Well, I was asked earlier if we'd established that internally, and we have. And so that's part of, you know, preparing for, you know, the open season and committed volumes within the transportation system. So we have established, you know, the rates internally that we're going to use.
Okay. But that's not technically a tariff, is it?
You could call it a transportation fee. We know what the rate is to ship CO2 on the pipeline.
And you talked about a requirement to not discriminate. But that's a FERC requirement, isn't it, for common carriers? There's no requirement like that for CO2 pipelines.
Objection. Calls for legal conclusion.
Well, he's the one that talked about the non-discrimination, and I want to follow up on that.
Okay, can you restate the question, Mr. Taylor?
Sure.
Please.
When you said that there's a requirement, or that the summit is not allowed to discriminate as to its customers. What requirement were you referring to?
Well, similarly to the question on tariff and requirements on the open season, these are internal, policies that we are considering. Right now, there's not FERC regulation on CO2, and I'm by no means am I a FERC expert, but we are planning for the future. If something were to come along, have we taken the correct prudent steps to position ourselves in that manner? And so I think there's we use those instead of requirements. We consider some of the policies as to be best practice, and we're contemplating those.
Now, Mr. Whipple went over with you your rebuttal exhibit 1, which is the ethanol study, I guess you'd call it, paid for by the Iowa Renewable Fuels Association, and that was done in February of 2023, right?
That's when it was released.
Okay. And I think Mr. Whipple asked you why that was prepared at that time. Isn't it true that that was right in the middle of the legislative session when the legislature was debating bills to restrict eminent domain for carbon dioxide pipelines?
I believe February 2023 is when the report was released. I'm not sure when it was commissioned or drafted. So during that time, to your point, there were bills in several states, that were contemplating different regulations along those lines. But I don't think you can say that this report was done specifically at that time because there were bills in place. I think this was, when we look through it, there's a lot of high-level things, but it also helped contemplate how the 45Z tax credit, which was part of the IRA, and it was a new concept for the industry, how that would be, how that revenue stream builds up and could affect renewable fuel economics.
But it certainly does focus on the carbon dioxide pipelines that were being proposed at that time, correct?
Sure.
I don't know if my page numbers are just like your exhibits or not, but on Roman numeral page 5, there's a legal disclaimer. Now keep going. There it is. Are you aware of that legal disclaimer?
I'm reading it now.
You hadn't read it before?
Okay.
Had you not read that before?
I'm sure I have, but it's a 93-page report, so I just wanted to glance at it again.
And it says, while the DIS, which is the company that produced this, has made every attempt to obtain the most accurate data and include the most critical factors in preparing the project. DIS makes no representation as to the accuracy or completeness of the data and factors used, or in the interpretation of such data and factors included in the project. Doesn't that indicate to you that maybe this board, which is going to make a very important decision, should perhaps be cautious about relying on this report?
I don't think, you know, that one sentence in a disclaimer is anything that I'd be surprised seeing in a legal disclaimer. So I don't think it affects the viability. I think this is makes some important, you know, high-level data points regarding the economics of ethanol and the impact of CCS and the tax credits and the revenue streams.
The disclaimer goes on to say the responsibility for the decisions made by you, meaning whoever's relying on this report, based on the project, and the risk resulting from such decisions remains solely with you, the entity making the decision, in this case the board. Doesn't that indicate that, again, that maybe the board should be cautious about relying on this report?
I think it's pretty standard language, and just with, as with all data points out there, you have to take into consideration what you're looking at and what the impacts of that are, and what weighting to give it. So I don't think anything in that legal disclaimer is surprising.
And as we've said, this report was prepared at the request and paid for by the Iowa Renewable Fuels Association. And you're aware, aren't you, that that association has been very vocal and very active and very involved in a number of ways in promoting the pipeline projects. Correct?
Yes.
I think that's all the questions I have. Thank you.
Thank you, Mr. Taylor. Ms. Ryan?
Thank you. Good morning, Mr. Pirolli.
Good morning.
Most of the questions I had have already been asked, so we're going to cut down my list quite substantially. But I want to talk to you specifically about how in your testimony you talk about needing to lower the carbon index in order for Iowa's ethanol plants to remain competitive. And so I want to talk a little bit about what that means in terms of being competitive. What kind of markets, in the U.S., the low carbon fuel markets, what kind of markets could they sell into?
The existing low carbon fuel markets in the U.S. are California and Oregon, and now Washington as well, so the state of Washington.
Now, earlier there was some discussion about sustainable aviation fuel. Is that a market that the ethanol plants would be able to sell into?
Yes, and that's growing and represents a significant opportunity going forward. We're seeing a shift in the technology from traditionally what was used were vegetable oils and distillers corn oil going into processes like such that produce renewable diesel, which could also be used to produce sustainable aviation fuel. However, looking at the demand long-term for sustainable aviation fuel and the feedstocks required for that, it appears that the alcohol to jet process is going to be the most viable going forward from the volume as well as the carbon intensity standpoint and the economics. And so that represents a very exciting market for low CI ethanol going forward.
And you also mentioned in your testimony that there might be more international markets opening up. Could you talk a little bit more about that?
Sure. So the country of Canada, for a number of years, there have been provincial low carbon fuel standard markets in Canada, but now the Canadian Clean Fuel Standard, the CFS, has been passed into law, and that will take into account the CI reduction on ethanol from the impact of carbon capture and storage, even if that were to happen, outside of Canadian bounds. So U.S. ethanol produced in the U.S., we do CCS in the U.S., that still impacts the life cycle analysis of the ethanol that would ship into Canada. And Canada is the largest export market destination for U.S. ethanol, and they're pushing forward on higher ethanol blends. So the Ontario, for instance, passed an E15 law, so we're going to see significant increase in demand for ethanol because of higher blends, as well as the benefit passing back for higher values as the CI score drops.
And with respect to the sustainable aviation fuel, is that something that could expand into international markets as well?
Absolutely. I think the demand for for aviation fuel globally, obviously it outstrips what we're seeing in the U.S. But I think that using low CI U.S. ethanol that presents one of the best economic opportunities out there. So that based on cost of production, CI score, availability, access to the markets, that's one of the largest opportunities that we have. That's globally.
Now, as demand for sustainable aviation fuel increases, could ethanol producers in other countries sell their ethanol into that market in the U.S.?
So are you asking, could ethanol producers in other countries sell ethanol to the U.S. for use in SAF or just in general?
And specifically SAF, but
Sure.
Any other purpose?
Yeah, and the U.S. imports ethanol already. So that's a possibility. I would think that, another option if a producer in another country was going to make SAF out of alcohol that they were producing, it's highly likely that they would do that, at the country of origin, but there's a lot of different opportunities.
Okay. So having a low CI score is important to compete in these markets, but wouldn't Iowa's ethanol plants still have to compete on price?
Yeah, that's a good point. But when you look at generally how LCFS markets, like California, in general, when folks talk about LCFS markets in the U.S., you're looking at California. It's the largest gasoline market, and hence the largest ethanol market for us, and has had a benchmark price for quite a number of years. And so when, in general, I mean, it can work different ways, but in general, if the delivered ethanol price in California is, say, $2.50 a gallon, that's what a buyer blender in California is willing to pay, and then the premium for LCFS credits is on top of that. So whatever the baseline is on the CI score that's agreed to, any benefit on top of that gets paid to the ethanol producer. And there's generally an interest in buying the lowest carbon gallon that's available, because there's only a set number of gallons that can be blended into the market, because that's directly in relation to the amount of gasoline that's sold. And so if there's, 14 billion gallons of gasoline sold in California every year, 1.4 billion gallons of ethanol, because it's 10%. So in order to maximize the number of credits, the ethanol gallon should be the lowest CI gallon available. So if the base price for ethanol delivered in California is $2.50 a gallon, that's set at whatever CI score is agreed to between the parties. And if the CI score is lower than that, then the buyer is paying a higher LCFS premium on top of the $2.50 a gallon.
Okay, so in markets like that, there's some stability in terms of price. But if we're looking at sort of an industry like sustainable aviation fuel, wouldn't purchasers have an impact on the price?
Yes, I think so. There's quite a few different variables that could impact the price that a buyer, typically you're talking about an airline is going to be paying.
So it is possible that Iowa's ethanol plants would have to compete with international ethanol plants in the sustainable aviation fuel market?
That's possible.
Summit Carbon Solutions is a subsidiary of Summit Agricultural Group, correct?
I don't know if I'd describe the relationship like that. Summit Agricultural Group was the initial founder and developer, but since then we've raised money from a number of investors, and they own a share, but it's not really a subsidiary relationship.
But it is essentially your parent company.
They are an investor, and they have members on the board of Summit Carbon Solutions.
Can you tell us how much of an investment Summit Agricultural has?
I'm not sure if that's exactly been disclosed publicly recently. It's a substantial share, but it's a minority share. They're not the largest shareholder.
Are you aware of the other operations of Summit Agricultural Group?
Somewhat.
Are you aware of their recent announcement to develop the world's largest ethanol to jet sustainable aviation fuel facility?
I'm aware of that announcement, yes.
Are you aware that Summit Agricultural Group owns ethanol production facilities in Brazil?
Yes.
Your Honor, at this point, I'd like to make a motion. I would like to move to have the board require Bruce Rastetter to attend to testify in person. Mr. Pirolli has testified that markets for ethanol, including international markets and sustainable aviation fuel markets, influence the price of ethanol. Mr. Pirolli also testified that Summit Agricultural Group owns competitors in the international ethanol market, as well as a large future domestic purchaser of ethanol, which could give Summit Agricultural Group the ability to control the price of low carbon index ethanol in the U.S. In the meantime, Summit Carbon Solutions can continue to make a profit off of the 45Q tax credits. The fact that Summit Agricultural Group would own both the ethanol plants and the sustainable aviation fuel purchaser and could impact market prices looks like a vertically integrated monopoly that would violate Iowa Code Chapter 553, subsection 5, which states that a person shall not attempt to establish, maintain, or use a monopoly of trade or commerce in a relevant market for the purpose of excluding competition or of controlling, fixing, or maintaining prices. Whether or not Summit Carbon Solutions' proposed pipeline is part of a corporate enterprise that violates Iowa's anti-competition law is highly relevant to whether the proposed pipeline promotes the public convenience and necessity. Therefore, it is necessary for the Utilities Board to hear testimony from Mr. Rastetter about the overall business model of Summit Agricultural Group and how various other companies, including Summit Carbon Solutions, fit into that business model.
Blinsky, I assume you have a response?
I do, Your Honor, to the extent that, that was sort of an ambush and we have to do it on the fly. No one has named Mr. Rastetter as a witness in this case. If Ms. Ryan wanted to subpoena Mr. Rastetter at a reasonable time instead of bringing it up in the hearing as a grandstanding ploy, there's been a long period of time to have done that, to have requested a deposition, to have requested his presence. That simply wasn't done in the normal course. In any event, the applicant is Summit Carbon Solutions, not Summit Agricultural Group. The testimony has been that Summit Ag is a minority investor, that Mr. Rastetter is one of many board members. He is not the CEO of the company. There is simply no evidence that he has the type of control that Ms. Ryan is speculating about, and it's certainly a reach to suggest that anything in evidence suggests that there can be some sort of a monopolizing vertical integration when not one of the 12 plants that are currently contracted for this project is a Summit Ag affiliate or a Summit Ag plant. And, there's no evidence of market concentration in SAF, in ethanol, in literally anything related to this. So I think that this is a highly frivolous motion, and I would urge the board to deny it. But if the board has any inclination to do otherwise, I would ask that they require Ms. Ryan put her motion in writing so we can have a fair opportunity to brief our response.
Do you have a response, Ms. Ryan?
I would be happy to put that motion in writing.
No, okay. The board's gonna take a 5-minute break and discuss this and be right back. So 5 minutes or less. We'll go off the record. Dated as discussed on the first day of the hearing by August 25th. So we'll go ahead and look forward to your motion in writing, and there will be 2 days to respond.
Thank you, Your Honor. And I don't have any further questions for the witness.
Oh, okay, thank you. Ms. Colas?
Hello, Mr. Pirolli. I'm Jean Colas with Colas Family Farms, and I had a few questions more related to the landowner. Is it correct that you stated that Michael Rory set the value of the land and the amount of compensation to landowners for easements?
I don't think I said that. I think there was a question related to the difference between fixed payments and ongoing payments and landowner compensation. And I said that Mr. Micah Rory is, that's his area of expertise, is the director of land in that area of responsibility.
So he's the director of land for Summit. And
He's in charge of right-of-way acquisition.
okay, so he would be the one that would set the price, or who would set the price?
He's involved in that process, and he works with Jimmy Powell and the management team and the group. So I think those are the questions for Micah.
Jimmy Powell indicated that he was not the one that made that decision in his testimony yesterday. So who would be responsible?
Well, that area does not come up to me, so it depends on that level of decision, but that's not the area of the company that reports up to me.
Will the person who is responsible be testifying? And what's the name?
Well, I believe that Mr. Rory can give you quite a bit of insight into that process.
Is he testifying in this hearing?
I believe so.
Okay, That's good, thank you. Okay. You seemed pleased that the landowners were receiving an upfront payment for signing the easement. Is that correct?
Well, I'm pleased that over 70% of landowners along the route have found terms that they believe are fair and reasonable, and that generally includes an upfront payment. And I think that's the set of terms that we have found overall as an organization that has been most widely accepted. So I'm always pleased when we reach voluntary easement agreements with landowners.
Have you ever offered any of them a staggered payment?
I think it's been discussed, but I have not offered anyone a staggered payment.
Are you aware that those payments were considered as a capital gain during one tax year?
Objection, Your Honor. This just is not the right witness for this, and I'm happy to suggest that Ms. Coles take this up with Mike or Rory, but I think this witness has testified several times that he's just not the person that's equipped to answer this line of questions.
Okay, Mr. Pirolli, Ms. Coles, I'm sorry, did you want to reply? Otherwise,
Well, I do want to have my questions answered, and if you say that Mr. Rory is the person he's going to be testifying, then I will definitely hold my questions until later.
okay.
Okay.
Mr. Pirolli, you can answer questions if you're able, otherwise you can defer.
Yeah, that tax area is not my area of expertise.
No further questions at this time then, thank you.
Okay, I don't see any other questions from the parties. The board has a few questions, and we can run through those pretty quickly, and then we can break for lunch. Well, I guess we'll turn the witness back over to someone before we break to lunch. While we're going through our questions, I just ask all of the parties to try to give us a rough estimate for planning purposes on how much time we think we'll need for confidential session. We're trying to avoid shuffling parties in and out of the hearing room, which is the reason we're doing confidential session at the end. We can always reevaluate if that's not the best way to do things, but to do that successfully, we'll kind of need a reasonable estimate on the amount of questions we'll have in confidential session.
And Your Honor, I don't want to interrupt the flow of the discussion with Mr. Pirolli too much, but we will want to spend a little bit of time at the conclusion of Pirolli talking about that, because we have some input that I think will be relevant to that, and perhaps some suggestions to try and help move things smoothly. So.
Okay. Mr. Pirolli, I apologize. I know you've answered at least a couple of these. However, it's difficult to check your questions off when you're paying attention to testimony too. So let's see if we can get the testimony pulled up. On page 5, lines 5 through 9 of your direct testimony, you describe how Summit Carbon will continue to offer its service. How does Summit Carbon go about making this offering?
So generally, from my my role, we have a good understanding, but always trying to educate ourselves with what industries and specifically which facilities are large CO2 emitters, and some basic understanding of the industry and the economics involved in that. We reach out to the companies and establish a relationship and discuss the future carbon strategy for their organization and their facilities specifically that would be within our footprint, and then continue to explore what a relationship would look like for capture, transportation, and storage services, or any subset of that.
Does Summit Carbon examine every potential party who seeks to interconnect?
What was the last of that?
Does Summit Carbon examine every potential party who seeks to interconnect?
Absolutely.
Can Summit Carbon reject an entity who seeks to connect its system?
Oh, I'm sure that we could. I mean, there's a range of, basic criteria, but I would say that our business is carbon capture, transportation, and storage. And so we're looking for partners, for shippers that, we can work with to bring that volume economically onto our line that would make a win-win relationship for both parties.
What percentage of the pipeline's transport capacity is already committed?
Well, if we consider the max to be roughly 18 million tons, and right now we've got about 9.5 million committed.
On page 6, lines 5 and 6 of your direct testimony, you state, unlike many large infrastructure projects in Iowa, because Summit Carbon is based in Ames, Iowa, more of these revenues will stay in Iowa and be reinvested in Iowa. What is considered as more of these revenues, and can you walk us through the calculation and the veracity of that calculation?
I think it's part of that is, our focus is to continue to invest in this 5-state area, but also specifically, in the area where our headquarters is. So we're going to not only develop and spend over $1 billion in the state of Iowa across these the compression facilities and the pipeline, but we are going to have our headquarters continue to be located in Ames. And so those are the jobs affiliated with running the company, the development of the control center with a redundant control center also, and all of the maintenance and technical services that are affiliated with that.
On page 7, lines 5 through 7 of your direct testimony, you state the Midwest lacks appropriate geological formations to sequester CO2. Did Summit Carbon conduct research to determine if Iowa had any viable sequestration locations?
We did, and it says much of the Midwest. So there are areas, depending on where you draw that boundary in Illinois, Indiana, and Ohio, where there are some good formations. But research was done. I'm not a geologist, but I do know that that was done not only for Iowa, but also eastern Nebraska, eastern South Dakota, and much of Minnesota. And so the criteria for those formations is not known to exist in this area. And believe me, we're not building the pipeline for fun. If it was possible here, we would be doing it. We'd be doing it here.
Has any other entity examined Iowa to determine if there are sequestration opportunities in Iowa?
So the basis for the testimony that I just gave came from the EERC, which is the Energy and Environmental Research Center in North Dakota, and their geologists, when they were looking at the depth of caprock and the depth of the formations, in addition to some other characteristics. There have been, some reports that say there could be geology here, but it's unknown. But specifically, from my understanding, because the formations are so shallow, even if there is caprock and the salinity is high enough, which is very questionable whether that exists or not, and it's unknown, that the very shallow depth of those formations
likely makes them unfit for storage of CO2 in a dense phase.
Has or could Summit provide those reports?
I believe we could get an opinion from an expert on that.
No. Staying on page 7, it looks like lines 8 through 9, you discuss truck and rail transportation. Do you know an approximation of trucks or rail cars that would be necessary to transport the same amount of CO2 Summit's pipelines is proposed to move?
Yeah, it is significant. Trucks get maybe 20 or 22 tons of liquid CO2, as opposed to a rail car that's between 60 and 65. That's around 300 psi. And so the CO2 is in a liquid state at that point. We see those trucks, specifically more trucks in Iowa, hauling to various industrial use facilities of that. But if you do basic math on 9.5 million tons divided by 65 tons in a rail car, it's a staggering number of trains that would be required, even if you take into consideration that rail cars are making multiple trips.
Okay, I think we can do the math on that later. On page 9, lines 9 through 13 of your direct testimony, you describe the nature of the off-tech agreements. So if we've answered this, you feel free to say you've already answered or refer to confidential session. Okay. Who owns the CO2?
So the ethanol plants own the CO2 until they transfer custody, and in this case ownership, to Summit at the title transfer point.
And remind us where the title transfer point is.
Your Honor, if I hate to interrupt, and awkward to object to a board member's question,
All right.
This really should be in confidential session.
That's fine. I appreciate that. Trying to find one that's not going to be in confidential session. It'll be easier to just reserve our questions for confidential session.
Mr. Pirolli, just one quick question. Dealing with one of the, I don't remember who asked the question about, can we sequester this? I think Mr. Helen, maybe Chair Helen asked that. If you can sequester in Iowa, are you aware of the National Energy Technical Laboratory? It's a DOE, Department of Energy lab.
NETL.
Yep, NETL.
Okay, I'm familiar.
And they have a facility in Morgantown, West Virginia. Has Summit reached out to them at all on accessing any of their research, any of their information that's been done on decarbonization and decarbonization projects?
I've looked through some of that information extensively. I don't know if a conversation with NETL specifically has happened between Summit and that organization since I've been here, but we are generally aware of their of their research and the things that they do. I'm not the expert there, but we are as it relates to some of the emerging technology and the carbon safe programs. I mean, we're generally aware.
So are you aware that that facility can actually do core samples for the viability of carbon sequestration underground?
That they have the capability.
Of analyzing the core samples. So if you were to take a core sample and send it into their facility, they can give you that feedback on whether or not it's a viable geological structure.
Okay.
Who would be a good person with Summit that maybe?
Wade Bayshans in our North Dakota office is our the management team member that is focused on storage. I believe when we sent core samples from the stratigraphic test wells in North Dakota, those were sent to a lab in Colorado and Denver. But I'm not sure if it was an ETL or not. I don't think so, but I'm not sure exactly who analyzed those.
Is there anybody that's going to be testifying that's more versed to that?
The person that would be most likely would be Mr. Powell, and I know that we are expecting him to be back on the stand at some point. Because the sequestration is primarily a North Dakota issue, we do not have Mr. Boshin's scheduled for here or any specific sequestration witness, but Mr. Powell would probably be your best bet on that.
Thank you. I have no further questions.
Okay, the board has no further questions. Mr. Dublinski?
Your Honor, I have no redirect on the public portion of the questioning thus far. So I don't know if you want to release the witness, then we can talk logistics, or otherwise I can just go right into logistics.
Yeah, let's release the witness for now, and then we can go into logistics.
Thank you.
Hold on. Thank you. Okay. Logistics.
Your Honor, notwithstanding some loose with the truth comments that were made in a recent pending motion, we had no special insight into the schedule, and we do not have particularly our non-party witnesses at our beck and call. And so on short notice, we were not able to get Mr. Phillips here today. He can be here tomorrow. Mr. Broghammer is here. We can move him up. I would not expect, and the other parties can tell me if I'm wrong about this, I would not expect Mr. Broghammer to be one of the longer witnesses. Mr. Skuvenek probably will be. And what I would ask the board's indulgence, what we found worked pretty well in Dakota Access, because inevitably you have these gaps with witnesses, is that having somebody that, even if they're on a couple different times, that is sort of always available to fill the gaps, worked pretty well. I would suggest Mr. Skuvenek, who will be here, is a good person to take as we can and fill gaps with if the board is amenable to that. What I would say, however, is I think Mr. Skuvenek will be a fairly long witness. So it may make sense to have the confidential on Pirolli before we start Skuvenek. Otherwise, we're going to potentially start Skuvenek for a limited amount of time, not know exactly how long, and then have to break and go into that closed session and come back. But I just throw that out there. I don't know if there's a great answer on any of this. We will continue to try and sequence and get people in town in a way that can keep the proceedings moving as best as possible. Again, some leeway to have sort of a designated fill-in for odd time gaps, I think would help with that. But Mr. Phillips can be here tomorrow, but he is not available to be the next witness.
Mr. Murray?
I certainly appreciate the thinking of Mr. Dublinski, and yes, it is true, there were some scheduling modifications within the Dakota Access case. I think it would behoove the board and all of us to know as to which witnesses are those witnesses that are likely to move, and those witnesses which will remain in the sequential order as listed, because obviously it does seem like we're running a little bit behind here. Thank you.
Mr. Taylor, did you have a comment? You nodded.
It's like an auction if you don't dare nod. My only comment is that we do want to reserve enough time today for the confidential session, and you had asked for our best guess as to how long it would take. I think with the number of attorneys we have, and apparently the board has some questions from Mr. Pirolli, I think we might want to set aside a couple of hours.
Mine will take about 10 minutes, if that.
Okay.
Thank you. So you're saying your confidential questions will take 2 hours?
No,
Okay.
no,
Thank
no.
you. Gotcha. Mr. Whipple.
I certainly agree with Mr. Dublinski that Mr. Skuvenek is likely to take more time than Mr. Brookhammer. And so the counties agree that moving into closed session for Mr. Pirolli and then coming out to begin Mr. Brookhammer might be a good way to proceed today.
Mr. Williams, did you have a?
I would just simply concur. And would agree that Mr. Pirolli would probably be the best to go next confidential session. Mr. Jorde, I was talking to him before this question came up. He thinks he would probably take about an hour with Mr. Pirolli in confidential.
Thank you. Appreciate that. Okay. Any other input? All right. Let's go to lunch until 1 o'clock. I want to discuss with the rest of the board. So we will plan on, hold on real quick. We'll settle this as soon as we get back for lunch. Just want to visit with the other board members real quick. And when we get back from lunch, we will start with Mr. Brookhammer. So we will go off the record until 1 o'clock.
I'm sorry, Your Honor, did you say at 1 o'clock we would go to Brookhammer next? Okay, thank you.